Okay, we're starting. Good afternoon. My name is Dave Ganadev. I'm the Vice President of the Medical Board of California. And Mr. Serrano Sewell, President of Medical Board, could not be here because of a long-standing obligation, so I'm going to run the meeting. So I have a few announcements. I want all of you to please turn off your cell phones to silent and make sure they are off the table so we can avoid feedback noise. You may notice board members accessing their laptops or tablets during the meeting. They're using the laptop solely to access the board meeting materials that are in electronic format. We're trying to save some trees. This is an official business meeting of the Medical Board of California. As such, disruptions of the board business will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individual listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star and 1. You will hear a tone indicating you are in the queue for the comment. If you change your mind and do not want to make the comment, please press the pound sign. Assistance is available throughout the teleconference meeting. To request a specialist, press star 0. Each person will be limited to 3 minutes per agenda item. And during agenda item 2, public comments on items not on the agenda, the board has limited the public comment period for individuals and people present here to 20 minutes. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Business services staff will be assisting me with receiving the public comments via teleconference during this meeting. The board welcomes public comment on any item on the agenda, and it is board's intent to ask for public comment prior to the board taking action on any agenda item. If, for some reason, I forget to ask for public comment on the agenda item, and you wish to speak on that item, please raise your hand or come forward and you will be recognized. And Ms. Webb will be reminding me anyway. I would like to request all speakers complete a presenter slip so I can call you by name at the appropriate time and the record of this meeting can be full and complete. However, this is voluntary. Please give speaker slip to Ms. Stoof. Ms. Stoof, right there. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make last-minute comment. I want to remind all speakers to please stay on the topic and keep your comments to 3 minutes or less. We plan to end the meeting today at 5:30 p.m. I would also like to introduce Kim. Kim will assist with individuals in the audience to introduce. I would like to call the meeting to the order and ask Ms. Stoof to please roll call. Thank you.
Dr. Bolat?
Present.
Dr. Bishop?
Here.
Judge Feinstein?
Here.
Dr. Hawkins?
Here.
Dr. Kraus? Ms. Lawson?
Here.
Dr. Levine? Dr. Lewis?
Present.
Ms. Pines? Mr. Serrano Sewell? Ms. Sutton Wills?
Here.
Mr. Warmoth?
Here.
Ms. Wright?
Here.
Dr. Yip? Dr. Ganadev?
Here. Thank you. Thank you, Ms. Stoof. Moving down to agenda item 2, public comments on items not on the agenda. Oh, these forms. Okay. Okay, I have 1, 2, 3, 4, 5, so please, 6. So please try to keep your comments to 2 minutes. Thank you. The first one is Leonard Sapoto, MD.
I'm representing California Citizens for Health Freedom. Frank Cooney, who's in the hospital at the moment, couldn't be here. And what I want to do is make a presentation about a law that is now in effect by the Department of Health that now affects all doctors who practice oncology, because it is a felony in the state of California under that public health law to practice any kind of medicine with the exception of chemotherapy, radiation, or surgery, which means even immunotherapy or diet or exercise would be a felony. So the Department of Health has the right to be able to come to any doctor who's practicing any of these approaches and make it a criminal allegation. So what I would like to show you is what I've presented you with is a bill that was put into law back in 2005 that says that any doctor can practice any therapy that he or she wants, so long as they first offer the mainstream approaches, does a proper physical examination and history, and doesn't do any harm to the patient. So already we have the means that we need to regulate doctors who do anything in any field of medicine. So this Department of Health law is unnecessary. It interferes with doctors in the state of California to be able to practice the way they want to under the laws and regulations of the medical board. And so what I'm appealing is for you to support legislation with the intent of passing new legislation that would take this particular item out of the Department of Health's jurisdiction. So I realize that there isn't a bill that has been presented yet, but if we have the intent of the board to support this, it would make it a lot easier to find somebody in the assembly who would support this bill and take it on and take it to the people so we can make a law out of it. So that's my request. And I'd like to be on the agenda at a future time to be able to have you vote on that or discuss it first.
Thank you, Dr. Sapoto. Next person is Janice Miller.
Can I have members of the public sit at this table here? That has your timer on it.
Can you hear me okay? So I'm a little nervous, first time I've spoken in front of you. But I'm here for reasons to talk about SB 277 and medical exemptions. Thank you for listening to me. My talk is about 2.5 minutes, so hopefully you can give me the extra 30 seconds. On June 29th last year, Senator Pan clarified the intent of SB 277 to the California State Senate before it voted. The law included an amendment allowing medical exemptions based on the recommendation of a physician, and that family medical history, may be considered to determine whether the vaccination is appropriate for the patient. Even as he shepherded this legislation through, he knew about the CDC whistleblower who came forward with an admission of fraud eroding the public confidence in the vaccine program. On a separate occasion, Ben Allen specifically stated that doctors not be sanctioned or impacted by using their discretion for granting a medical exemption, and anyone who has a legitimate medical concern, he said, can get one. They are in the physician's judgment. Under the letter of the law, Doctors can write medical exemptions, but there is a lot of pressure in the medical field not to give them. I understand that 99.9% of children under federal guidelines do not qualify for a medical exemption. We know vaccines harm. Otherwise, the pharmaceutical industry would be liable for those products. And we know that $3 billion has been paid out in death and injury claims by the Vaccine Injury Compensation Program. So that in itself proves that it's true. They do harm some. So these conditions put a lot of pressure on every licensed physician in California. SB 277 does not contain a provision that allows school districts, health departments, or anyone else to review or reject a physician's medical judgment. But it's happening. It started with the Santa Barbara Medical Exemption Pilot Project.
Please conclude.
Thank you. These actions not only violate SB 277, but as I understand, may also violate many federal and state privacy laws. So, two more things I want to bring. With the machine in place to trump every medical exemption, trust in our legislators, our medical community is eroded. Freedom as we know it has ended with SB 277. And I've come here today to ask each of you to support my right, to support all of our rights to make informed medical decisions with our doctors about vaccination, without coercion, without the threat of investigation due to complaint or loss of medical license, to let doctors use their judgment to write a medical exemption without risk. Thank you.
Thank you, Ms. Miller. The next person is Jessica Butcher, it looks like. Forgive me if I butchered your name.
I'm very used to it.
I have the same problem, so go ahead.
I'm also here to speak on SB 277, and I will try to keep my comments so that they aren't overlapping too much with this, who spoke before me said. I'm here because the letter that Dr. Charity Dean sent out really raised a lot of red flags for me. And if you are not aware, on June 6, 2016, she sent out a letter stating to all school superintendents, principals, and child care center directors to send all medical exemptions for a, quote, comprehensive review of each exemption for the purpose of data collection and compliance with SB 277 criteria. When Governor Brown signed SB 277 into law, he explicitly stated that the legislature specifically amended SB 277 to exempt a child from immunizations whenever the child's physician concludes that there are circumstances, including but not limited to, family history for which the physician does not recommend immunization. Given what the governor has stated, it is clear that there is no need for Dr. Dean to perform a comprehensive review of each exemption, as she is not the child's doctor. She has absolutely no reason to burden the schools or anyone else with any additional steps, as the child's doctor has already concluded that the medical exemption is warranted, which is exactly in line with what Governor Brown has stated when he signed the bill into law. It is my summation that Dr. Dean and other department heads are using their positions to circumvent the explicitly stated authority of the child's physician. I respectfully request that you tell her and others in her position to stop usurping the law. Thank you.
Thank you, Ms. Butcher. Next person is Christina Hildebrand.
My name is Christina Hildebrand. I'm from A Voice for Choice, which is an organization that advocates for anything, for people to have informed choice and transparency of anything that goes into their body. I too am here to speak about vaccinations and the role that doctors have in writing medical exemptions. When you talk about vaccines, especially to doctors and many doctors, it's a taboo subject as a consumer, as a patient. But it's something that, you know, most doctors will say they're safe and effective, but they're not 100% safe and effective. And there are children and adults who do get injured by these vaccines. Unfortunately, there's no way of telling or explicitly telling which child is at risk or which adult is at risk and which one is not from the vaccines. The vaccine schedule that the CDC has, the 72 doses by the age of 18, has never been tested in its entirety to see whether it is completely safe. I see two issues here that I would like you and I ask you to look at. One of them is that the insurance companies are giving kickbacks to doctors to have their children that are under age 2 or by age 2 fully vaccinated. There is up to $400, maybe even more, being given for every child that is vaccinated fully, which means that doctors are not looking at whether a child, what the risk and the benefit is. They're looking at their bottom line. $400 is a very nice amount per child under the age of, or who gets to 2 and is fully vaccinated. So I'd like you to look at the Stark Act and the kickbacks that those doctors are getting for fully vaccinating their children, and whether they truly are looking at the risks and the benefits for each and every child. The other thing that I see is that there is no recourse for patients who do get injured, not severely injured, but just have a seizure or have some reaction to a vaccine, because under the Vaccine Compensation Act, you have to have had an anaphylactic shock or have died from the vaccine to go to that program and request for monetary compensation.
Please conclude.
I will. So the other piece of it is that there are many doctors' practices that are now throwing children out of their practice because they are not 100% vaccinated, which again, if you're looking at each and every child and looking at the risk and the benefit of a vaccine for that child, you need to have a doctor allow children in there that are not 100% vaccinated. And that comes from either the corporations that they're working for, such as Kaiser or Stanford or other larger corporations having a say of you must have vaccinated children, or from the insurance companies. And what that leaves you with is a very few number of doctors who are in private practice, don't take insurance, who are willing to look at these children holistically. So I ask you to do those two things. Number one, to look and investigate the kickbacks that doctors are getting. And number two, really look at whether the doctors are doing no harm by having the children 100% vaccinated in their practice, because 100% of children
Please wrap
should
it
not
up.
be vaccinated. Thank you.
Thank you, Mr. Elbrand. Next one is Andre Angelantoni.
Good afternoon. We each have a 2-minute comment. Thank you for the opportunity to speak with you today. So good afternoon. My name is Andre Angelantoni, and I'm a resident of San Francisco. Though I'm not in medicine, I have a Bachelor of Science degree, and my science background includes being a co-author of 2 academic papers, including one in the Philosophical Transactions A of the Royal Society. So I do have some experience in how to gather rigorously evidence for a hypothesis. I plan on being a parent one day, and I intend to discuss the scientific basis for permitting parents to work with their doctors to choose whether and how much to vaccinate without mandates. Specifically, I'm going to talk about recent advances in our knowledge of how repeated immune activation due to aluminum adjuvanted vaccines may cause vaccine injury, including autism. It's commonly thought that vaccine injury is limited to some soreness in the arm, a slight fever, and in those allegedly rare 1 in a million cases, some paralysis or even death. Injury rates are currently seen to be so low that the benefits of vaccination far outweigh the drawbacks. In most people's minds, autism is absolutely not caused by vaccination. Fortunately, recent work by Caltech, UC Davis, and other groups is providing us the biological mechanism behind much vaccine-induced autism. Their work is showing how, first, maternal immune activation increases interleukin-6, and that is strongly pointing to the biological mechanism. It's long been known that infection during pregnancy causes autism and schizophrenia, and it wasn't the infection per se, but the mother's immune reaction to the infection that caused it. In 2005, Vargas et al. At Johns Hopkins showed that most brains of the autistics they autopsied were inflamed. In 2009, Caltech tested the theory that purposefully elevating interleukin-6 would cause inflammation. They found the mice exhibited autistic behavior.
Your time is up. Please conclude.
In 2014, Caltech partnered with UC Davis and performed the same experiments. By elevating interleukin-6, they were able to produce autistic monkeys. Emily will continue.
Good afternoon. Thank you for your time. My name is Emily Bentley. I have a bachelor's of science in kinesiology, and I am a successful business owner in Berkeley. I am also a mother of a child who is partially vaccinated and is not able to attend kindergarten. To continue on some of Andre's points, other groups corroborated the maternal immune activation work. Panita's group at the School of Medicine at UCLA published their work with mice and stated that interleukin-6, IL-6, is necessary and sufficient for producing autism in offspring. Wise group at the New York Institute for Basic Research replicated Patterson's work and showed that elevating interleukin-6 via a genetically modified virus caused autistic behavior in postnatal mice. This evidence shows that elevating interleukin-6 will cause autism. What else raises interleukin-6? Aluminum adjuvanted vaccines. Up to 60% of the vaccines on the CDC infant and childhood immunization schedule include aluminum adjuvant. Aluminum is included to activate the immune system, and without it, the body would not recognize the weakened antigens and would not create the necessary antibodies. Vaccine adverse reactions can stimulate enormous IL-6 production in the brain in the same amount that causes brain damage in experimental animals. The studies supposedly disproving the link to autism consider only the MMR, measles, mumps, rubella vaccine. Aluminum-containing vaccines have not been studied, with the exception of hepatitis B, which is strongly associated with autism. Also, an epidemiological study by Shaw's group shows that exposure to aluminum from vaccines is associated with autism within the United States and across 7 developed countries. Vaccine promoters are using the MMR studies to argue that all vaccines have been proven safe. But this is dishonest and a misuse of this science.
Please conclude.
Vaccines are different, and the MMR does not contain aluminum. There is powerful scientific evidence for the mechanism by which and the ingredients in vaccines causing brain damage and autism. I urge you to consider these facts when conducting reviews, as physicians must be free to practice medicine in view of the latest science and how it relates to an individual's care. Thank you for your time.
Thank you. Thank you, Mr. Angeltoni, and thank you, Ms. Bentley. Are there any other?
Actually, if I can just say, we did give some handouts with the citations for the mice and monkey studies. We'd like to respectfully request that the board receive them.
Thank you.
And those were handed out to the members.
Thank you.
Any other public comment from people who are here? If not, comment on the phone.
Do we have any comments on the line?
Yes, we do. We turn to the line of Gene Dorio. Please go ahead. Your line is open.
Thank you.
Go ahead, please.
Great, thank you. My name is Gene Dorio, D-O-R-I-O, and I am a licensed physician in Santa Clarita, California. Thank you for allowing me to address the medical board today. You know, I've been at Henry Mayo Hospital and seen their HMO hospitalists not provide standard of care to their patients, to their ill patients. The chief medical officer, a hospital administrator and California licensed physician, changes policies and procedures resulting in the deaths of patients. The hospital board of directors...
Doctor?
Licensed
Doctor, forgive me.
Yes.
But if this is a matter that may involve a complaint, that may come before the board members, it's not appropriate to go into specifics.
Complained already. This is not a complaint. This is a statement. Hopefully you will bring this to your agenda or have it in committee. So they are not, these are things that I have found that I'm alluding to so that I can present this and makes more sense to you.
Is this involving a specific matter? Because
No.
it sounds like
No,
it.
it is very general.
Okay, just don't go into specifics, please.
Well, they weren't specifics, they were general.
Okay, it
Those-
sounded
those
like
to
it was
me,
going down that
If I
path,
were giving
so.
you specifics, I would give you names and dates, which I can do, but I have elected not to.
Yeah, you've identified the hospital, so that's the concern.
Well, in Santa Clarita, and we only have one hospital here, so it would be very easy to figure out which hospital. I'm sitting in their parking lot right now, so if you had GPS on me, you would know.
Please,
that's where I am. You know, so I
please
will-
continue
I
with
will
your
refrain-
comments.
I will
Please start his
refrain
time again.
from the hospital.
Please continue.
Should I continue?
Yes, please.
Good, thank you. I appreciate it. In addition, I've seen doctors who place their patients, elder senior patients, on hospital just for the benefit of their organization's financial needs. Outside the hospital, as described in 60 Minutes, there have been continual denials of requested medical care by California licensed physicians employed by insurance companies. They have been not held accountable for their practice of medicine under the guise of utilization review. I sense the California Medical Board might recognize utilization review lies within the realm of the practice of medicine, but seemingly to me, you are awaiting California legislators to define your legal jurisdiction. The highest priority of the medical board is to protect the public and should not wait the intrinsically slow legislative process. Plus, any new laws will have fingerprints of lobbyists and special interest groups, forcing the board to continually clarify complicated wording through your legal counsel. The Medical Practice Act might provide a legal tool to fulfill your fiduciary responsibilities for the purpose of appropriate patient care. I'm not an attorney, but Section 2018 may allow oversight of licensed physicians who are not practicing standards of care medicine. This discussion needs to take place as public confidence in physician medical decision-making has eroded because of business intervention. The unscrupulous and sometimes immoral practice of medicine influenced by profit must be deterred. Other than your board, there is no other California agency that can wield this power and lift the standard of medical care for the public services. The public has no place to turn, or do I? I hope the medical board will find a place on their agenda within a panel or an advisory committee to bring these issues forward. Thank you.
Thank you, Doctor. Any other comments on the phone?
We have no further comments on the phone lines.
Thank you. Now we go to agenda item 3. Oh, I'm sorry. Oh, we have, yeah, please. Identify yourself.
Yes, I'm Eileen Ellis of San Francisco. Thank you for this opportunity to speak with you briefly today. I'm a mother of 2 boys, ages 5.5 and 9. I'm here today because I'd like to see SB 277 reformed, and I see that my rights as a parent and those rights of my children are being violated. You see, our family has significant history with autoimmune dysfunction and neurological dysfunction. We are also concerned about aluminum vaccines, the body's known challenges in processing it, and the effects of aluminum on a young child developing body when given multiple vaccines at one doctor's visit. Because of this and family history, we made an informed decision to vaccinate our children on a delayed, one-at-a-time schedule. And while my older son has a neurological concern and has been on hold on vaccinating orders for over 6 years, my younger son, who is so excited to go to kindergarten in 2 weeks, may be denied entrance at his brother's SFUSD elementary school because he is 5 vaccines away from being compliant with SB 277. By maintaining SB 277 in its current form, the state of California is violating my children's rights, children who are dependent on their parents to consider family history and apply healthcare choices we see necessary to support lifelong health and vitality. I ask the California Medical Board to work to adjust SB 277 in consideration of families like mine. Thank you.
Thank you. Well, last chance. Any other public comment on items not on the agenda? Okay, that item is closed. Item number 3, approval of minutes of May 5 and 6 meeting.
I move to approve the minutes.
Okay, please go ahead.
On page BRD 3-5, agenda item 8, that Ms. Birchmeyer stated the FSMB would also be taking a look at physician compounding, amongst other topics. I believe the word compounding was intended to be burnout or something.
You're looking at sterile compounding.
Oh, I'm sorry.
Yeah.
As Hilda would say.
All right, Dr. Cross, you're excused. You need to take some English lessons.
Nice comeback.
Any discussion? Any public comment from the audience? Any comments on those on the phone?
Do we have any comments on the line?
No, we do not.
Thank you. Ms. Toof, roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson? Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright?
Aye.
Dr. Yip? Dr. Gonadev?
Yes.
Thank you.
Okay, now we'll go to the item we are waiting for a little while. Item number 4, presentation on the End of Life Option Act. Our speaker today is Dr. Grube. Just a little brief introduction of Dr. Grube. Dr. Grube was born in Eugene and raised in rural Oregon and Alaska. He received a BA cum laude in natural science at Lewis and Clark College in Portland, Oregon. He spent most of his senior year abroad studying public health in Austria. He graduated from the University of Oregon Medical School. In the 3rd year, there he received a AAMC USPHS scholarship, fellowship to the former Yugoslavia, where he witnessed a smallpox epidemic in Belgrade. Dr. Grube completed his internship in Tucson, Arizona, and then became a commissioned officer in the United States Public Health Service. He was stationed in Grand Coulee, Washington for 3 years and moved to Philmont, Oregon in 1977, where he founded Philmont Family Medicine. He practiced family medicine there for 35 years, retiring in 2012. He was board certified in family medicine 1977 to 2015. He has been a leader in the Oregon Academy of Family Physicians and was the founder of CAFP Foundation, OAFP, California. Always stays in my mind. OAFP Foundation. He was appointed to the Oregon Board of Medical Examiners, now Oregon Medical Board in 2001, and served 7 years, 2 years as the chair. He was chosen OAFP Family Physician of the Year in 1986 and Oregon Medical Association Doctor Citizen of the Year in 2009. Dr. Grube has taught paramedical and medical students for his entire career. He has lectured nationally on topics such as professionalism, medical ethics, end-of-life care, and humor in medicine. He has served his local school board, his local hospital board, and is again on the board of local hospice. He is National Medical Director for Compassionate Choices for Oregon. Dr. Grube, please go ahead.
Thank you very much for the invitation to come speak with you today. Greetings from Oregon, and a special greetings from the Oregon Medical Board, particularly Executive Director Kathleen Haley and in Oregon, we have a medical director, which you don't have in California, but Joe Thaler also wants to welcome you. And I want to particularly thank Kim Kirchmeyer for all the support that she's given me to come today and in our discussions about your new End-of-Life Option Act, which is similar to the Oregon, what we had called Death with Dignity Act. And what I hoped to do today was to educate you a bit about this act as it's integrated into the Medical Practice Act of California, and answer any questions that you might have. My idea is that we have experience in Oregon of about 18 years of what this act has meant for us, and because I was on the Oregon Medical Board, I understood that impact, which, by the way, is very small. So that my goals today are to review the medical aid in, the idea of medical aid in dying, the Oregon revised statute, and I'll be very short about that. Review your California End-of-Life Option Act, which is essentially the same. It's really, there's very few differences. We'll talk about them. And discuss future implications for the Medical Board of California in this regard, and then I hope to answer questions. I know you have a lot of work to do, and so I'll try to keep my comments brief. And the first thing I was going to say, and I forgot to say, but I wanted to thank each of you, every one of you, for your service to citizens of the state of California. Very few people know how hard it is to be on a medical board and do the work that you do. I happen to know because I was on the board, and it's an unbelievable amount of work, and thank you for what you're doing. I got the sources of information that I'll provide with you today besides my own personal experiences come from our state epidemiologist, who is Katrina Hedberg, as I mentioned, our Oregon Medical Board, and George Amy, who is an attorney and was a legislator who was one of the people who drafted the Oregon Act and also consulted your assemblymen and senators in California when you drafted this act as well. I have a few hats, and your acting chair mentioned them, so I'll skip that. But I want to remind us why we are here, and it's really about medicine and to cure sometimes, to relieve often, but always to comfort. And my opinion, and I guess I'm sharing this mostly with the non-clinicians in the room, and I know your board has way more lay members than we have in Oregon. In Oregon, we only have 2 lay members, and I think you have 7. So that's great. But anyway, in end-of-life care, in my mind, and this is my perspective, is to care for the patient. This is what licensees should be doing, California doctors, to teach the patient and their family to respect the wishes of the patient and to comfort and alleviate suffering. When I went to medical school, this is what I thought I would do, is that I would keep all my patients alive forever. And of course, after I practiced for a long time, I realized that that's not the case. We're talking about end-of-life care, and this End-of-Life Option Act discusses that. End-of-life care has many complements. It has full treatment, take everything that you could possibly do. Atul Gawande talks about that in his book, Being Mortal. Declining treatments, some are all treatments. That's patient autonomy, has the right to do that. And we have a lot of unwanted medical care because we doctors don't explain in shared medical decision-making what the outcomes might be. Hospice and palliative care, I am on the board of a hospice, and I believe in hospice strongly. Stopping eating and drinking. Terminal sedation, which palliative care doctors do on rare occasions. And then medical aid in dying, which is what we're talking about today. This is not an end-of-life option. If I'm ever on life support, unplug me, then plug me back in and see if that works. The art and science of medicine include these things: patient autonomy, shared medical decision-making, and professionalism, professional integrity, and then our personal beliefs, which impact our decisions whether or not we would be a part of this. Medical aid in dying is now legal in 5 states, 4 states by referendum and legislative vote, and in Montana from action of the Supreme Court. This is something that I projected, and I don't know that it's true, but anyway, we're a little state compared to you, about 1/10 of you, maybe 1/9 of what you are. And in Oregon, we get about 3,500 requests for information regarding aid in dying, which we call Death with Dignity in Oregon. So I would imagine that in California, you're going to get 30 to 50,000 questions a year about this. And so that's why we all need to understand what it is and how to answer the questions. We have 18 years of data and experience, and that's what I bring today as an Oregonian to share with you. The problem I have with our law is that it's called death with dignity, and I think the dignity is defined by the individual, not by a law. And so I think your law has a much better name than ours, because if you're dying in the ICU with all the tubes in you, and you believe that that's what you want, and that could be dignified for you. So choosing any option could be dignity. But anyway, there's 5 components to these laws, to your End of Life Option Act and to our Medical Death with Dignity Act in Oregon. The 5 components are that you need to be a resident of the state of California, that you need to be 18 years or older, that you need to have a terminal diagnosis as determined by 2 different physicians, that you need to be volitional, it's your choice, it's no one else's choice, patient autonomy, and that you have to be mentally capable, decisionally capable in this regard. So the law that you have in California, which is similar to the law in Oregon, tries to outline protections for the citizens of the state to make that be, all of those components be present. It requires 2 physicians. It has to be either an allopathic physician, MD, or osteopathic physician, cannot be a chiropractor or a naturopath. One physician is the treating physician or attending physician. The other physician is the consulting physician. If either of them uncover a mental illness that has an impact on the patient's condition, then a 3rd physician should be consulted, and that would be a psychiatrist. And all of the 2 main doctors must confirm the patient's eligibility in those 5 components that I mentioned to you. There's a process that you go through. There are 2 oral requests from the patient, and these must be at least 15 days apart. There is a written request after the doctors have evaluated the individual, and the written request has to be signed by 2 witnesses, and then the prescription cannot be written until 2 days after the written request has been completed. The physician, the attending physician, treating physician, needs to inform the patient of all feasible alternatives, and this must be documented in the record. The alternatives of hospice care and palliative care and pain control. And he should or she should request that the patient notify the family, although that's not a requirement. There are forms that we have in Oregon that are similar forms that will be in California that the doctors must send in and complete. And I'm going to talk about that a little bit more in a second. It's a little different in California than it is in Oregon. And the pharmacy should be called and notified, and then there are follow-up forms after the patient has died. A few little statistics for you, and these are just some information that sometimes surprises people. The main take-home points that I want to share with you is that this is a rare thing in Oregon. We've had it for 18 years. It's still less than 0.3% of deaths, and that fully 1/3 of people who get the prescription do not take it. 1/3 of people who get the prescription, and therefore, in my opinion, and the opinion of a number of other people, this is a palliative act. Just getting the prescription is a palliative act. This graph demonstrates that thing that I just mentioned, that in the green are the people who actually took the medication, and in the blue are the prescriptions that were written. And so while it has increased over time, as has the population of Oregon, we're growing very fast, it's still between 0.2 and 0.3% of deaths per year, very rare, very uncommon. Last year, for example, we only had 218 prescriptions written. They were written by 106 different doctors. The wonderful thing about this as a possible consequence is that our hospice penetration and use has increased dramatically, and now we have 92% of patients who choose or consider aid in dying are in hospice, get to die at home, and for the most part, these are people who have health insurance. We have it's not very often common, but about 27 cases out of the 200 and some odd cases was a physician or nurse was present at the time of the death. In Oregon, the Oregon Medical Board and the University of Oregon Medical School at that time our only medical school, and the Oregon Medical Association got together and came up with the guidelines for healthcare professions regarding what you would call the End-of-Life Option Act. And it's a big, long 500-page thing, but I brought for you just a couple little vignettes from it that relate specifically, I think, to the California Medical Board. This is in regarding to professional noncompliance under Chapter 12, and these were co-written by our executive director. If a licensee of the state of Oregon recognizes that there is inappropriate use of the End-of-Life Option Act, she or he must report this to the Oregon Medical Board. And if there's concern about other healthcare professionals, it is incumbent upon licensees in the state of Oregon to report those also to their respective boards. Also, under 12.3, under this guideline, if a health professional has questions about whether end-of-life care has been being appropriately provided, they should consult the staff of the medical board. I do want to compliment, again, Ms. Kirchmeyer and the staff of your California Medical Board for having already put in place and published information regarding your End-of-Life Option Act, and you actually even have, as you probably all know, a little link that citizens of the state of California can contact your board to get information regarding the End-of-Life Option Act. And other components of our guidelines are talk about overprescribing and underprescribing. And we were the first state in the union, the medical board, to discipline a physician for underprescribing medication at the end of life. And if individuals have good faith compliance, licensees should not be reported, and this is not unprofessional conduct if licensee is obeying the ORS 127. Now, our Oregon Health Authority, which I think I can't think of the name of it again, in California. Anyway, I talked with our state epidemiologist, who is the one who's responsible for writing the report every year. And she just described the types of concerns that they have. The vast majority of concerns that run into her when she goes through all the reports that physicians and licensees in the state of Oregon are obliged to send in are paperwork problems. They are things like putting the dates down wrong, not documented that they did all the many steps as you go through the process. And so in Oregon, she and or her staff investigate those simple problems. And if there seems to be a bigger problem than that, it's then sent on to the Oregon Medical Board, and that's about 2 a year. About 2 cases per year are sent to the Oregon Medical Board. And as I showed you in that one graph, as the number of cases have gradually gone up, that hasn't increased. She still sends in about 2 a year to the Oregon Medical Board. So the Oregon Medical Board does a review of each of these. We're different than you in that we have a medical director. So our medical director is, and I've been a pro tem medical director for our Oregon Medical Board. We look at those. I talked with Ms. Kirchmeyer, who objected a bit to our letter of concern approach, but you have a thing that you can do from your board too, so that if a licensee in Oregon makes one of these little paper mistakes, that doesn't go to discipline, it doesn't go to the data bank. We send them a letter and say, there's been an error here. You did the intent of the law, but you didn't do it exactly right. Don't do this again. And then if there are errors that occur again, that would then raise to the level of investigation, and that has never happened. There's never been, in the 18 years that we've had this law in Oregon, any licensee that's ever been investigated and subsequently disciplined for inappropriate use of our Death with Dignity Act. Is that going to be the case in California? Who knows? But you have, my idea is that it may not be as big a problem as people worry about. So I've tried to compare the two bills. They're very, very, very similar. And if I could, as a non-lawyer, come up with the differences in the two, You have to be a resident of Oregon, but it isn't as specific as it is in California. In California, there are specific things like a driver's license, tax forms, et cetera. In Oregon, we say those could be ones, but if you say you're a resident of Oregon, you're a resident of Oregon. People don't move to Oregon just to get this done. There is the case of Brittany Menard, which is, of course, a very, very famous case, but these people are very sick. These are very, very sick people, and they're not really able to come to Oregon, and it won't be something I think that you'll see in California. The attending physician is responsible in California for all the forms, and the attending physician in California must see the patient alone to make sure that they're volitional. The only change there is if there's an interpreter. In Oregon, we don't have any of these rules and regulations regarding an interpreter, and the physician does not need to see the patient alone. The consulting physician in California is called an independent physician. That's not called that in Oregon. And we don't have this thing called a 48-hour attestation form in Oregon. That form is a form that the person who's considering choosing aid in dying must fill out 48 hours approximately before they choose their end-of-life medication, and then that becomes part of the medical record. We don't have that in Oregon. And I don't think it's outlined in the California Act about the death certificate. In Oregon, it is outlined that aid in dying cannot be written on the death certificate. It can only be the terminal disease, lung cancer, etc. If you write aid in dying or death with dignity on the death certificate in Oregon, you get as a doctor, the doctor gets it back, and you have to put in the terminal diagnosis. And you have a 10-year sunset law on yours, so that's going to be reviewed in 10 years, and ours has not. Ours is permanent unless it's voted out. And the other amazing thing about ours is that it hasn't been changed really in 18 years. So I want to bring up a couple special points about your End-of-Life Option Act, about the importance and the value of hospice care and palliative care, and the doctors specifically talking to their patients about that and documenting that, because I'm such a believer in hospice care. Both of these are about that. And then again, that's if you abide by these rules and regulations, there's no any kind of disciplinary action or penalty or criminalization of a doctor prescribing medications. I think you have this in your folder. I just used the phrasing is so similar between what the attending physician is, but it's a little bit different in the consulting physician. You say who is independent, and I asked Ms. Kirchmeier how the staff interprets that, or your legal advice interprets the word independent. And then the attestation form, as I mentioned, you have in California. We do not have that in Oregon. What are the barriers for the citizens of Oregon, which, as you know, is one of the 4 main tenets of medical ethics, social justice. Main barrier is lack of education by doctors and lack of education about patients, that they have the option and know about this. And then another barrier is that these people are dying, and many of them just don't have 15 days to, when they decide this might be something that they want to do, to go through the whole process. In Oregon, the average or median time for a person who said they would like to consider medical aid in dying and then actually proceeding and going through the whole process is 48 days. And then some places in Oregon, it's impossible to have this happen. We have a town called Roseburg, which is on I-5. Roseburg has a Catholic hospital, and all the physicians' practices are owned by a Catholic church, with the exception of about 3. And they do not allow any of their individual citizens of the state to access this law. So if you are a citizen in Oregon and live in Roseburg and want to consider death with dignity, it's not really very possible. And some medical providers who are opposed to the law have provided patients with misinformation. We've uncovered this, but not to the level of discipline, or delay the patient from starting the process. So this is your wonderful website, which I've been to, and I like it better than ours in Oregon, but don't tell Kathleen Haley that. I think you have a great website, and I know you're going to make it better. I saw that in your earlier presentation. And there's information on your website. So what are some concerns that you might have? And these are the ones I dreamed up, and you probably have different ones. So what is the intent of this law, and how to deal with licensees who violate it? How are you going to deal with the pure paper problems that you have, which will be the vast majority of situations you'll have to review? How are you going to deal with complaints from the citizens, legitimate or non-legitimate? And how does the respond to opponents who may obstruct the citizen of California to have this option? This is a website that the group that I work for now called Compassion and Choices has. And this is a website called endoflifeoption.org. And we've made a number of videos for patients and for doctors to consider the clinical practice guidelines for the End-of-Life Option Act in California. 3 of these are on this website that you can see if you would like, or if you could refer to. We have 6 more of them, and we're trying to get continuing medical education through UCLA. And it's just about done. And this just provides clinical practice guidelines for your licensees if they're considering this option or their patients ask them, so they can become educated. So this is the website, our website, that has that. And it says resources for doctors there, the second one on the top. This is the chapters, medical aid in dying and the physician's role, what a physician should consider when responding to a patient's request, the process and liability protections. Those are the 3 chapters that are out in the public now, but the other 6 we're trying to get CME for them. This is a resource for your licensees on the clinical practice guidelines that was written by several authors, a couple of which are at UC Davis. I think Dr. Ben Rich is at UC Davis. And so here are my conclusions for you. It's not common. It's a very uncommon thing, but it is going to be integrated into the California Medical Practice Act, and that you should all learn about it and understand about it. There are barriers that citizens of the state of California will encounter, and the law is not necessarily easy to navigate, whether it's from the citizen or the licensee. We have not uncovered licensees who have violated the intent of the law in our 18 years. And we have had unexpected consequences in Oregon, which we believe have all been good. There's no slippery slope to other changes. There has been no abuse for the disabled or the poor that's ever been uncovered. And we believe it's improved end-of-life care. So that's my presentation for you today. Thank you for listening to me, and how I could respond to any questions, I would be happy to do so. Thank you again.
Thank you, Dr. Grube. And before I go to the rest of the board, I have a couple things. Have you ever done a poll to see what percentage of physicians are willing to participate and how many are not willing to participate in Oregon?
There are many different polls that have been done, and to my knowledge, in Oregon, not specifically in Oregon. There are different polls that have been done nationally. There's a Medscape poll of about 2,000 primary care physicians, and they ask the questions in different kinds of ways. There's been different kinds of polls in the state of California. I know there was one that was done in Berkeley. Of course, the important question is to ask, individuals, doctors who are going to, the subspecialists who are going to be involved in this, not the dermatologists and the pathologists. And so roughly, if I can answer your question roughly and consolidate all those kind of non-parallel polls, approximately 50% of physicians support medical aid in dying, and approximately 30% of physicians are opposed to it, and 20% of physicians don't know what they think. But that's a great question, but of course this isn't about us doctors, really. It's about what the citizens want, what the patients want, and then whether or not we, through professional integrity, could support their wish. So it's a great question. It's about half, I would say.
And the next one is that you showed that about a third of the patients don't follow through. My curiosity on this one is, with the opioid epidemic sweeping the country, you had any trouble somebody else using those drugs to?
Great question. So we don't use opiates. That's not one of the main protocols. It's a short-acting barbiturate, secobarbital, which is essentially not used at all. It's not a pain medication. It was originally a sleeping medicine. So opioids really aren't used for end-of-life medications. People who are dying, as you know, I believe you're a surgeon, right? And these people have a whole host of medications in their bathroom as they're dying from their cancer or whatever that are very, very dangerous. And secobarbital, which is a medicine that people take as a aid in dying medication, is dangerous and should be used with great respect. But it's not really in the opioid family, as you know, at all. And there are other protocols. There is an opioid protocol for the opiate naive patient. Very rare dying person who's opiate naive, but there are ALS patients.
Okay. Board members?
Yes.
So my question is, so oftentimes there's discrepancies with someone who says maybe they have a terminal illness, and I know with the most famous case, she lived an additional 6 months with the brain cancer. So how does one reconcile the ethical duty that the doctor has to ensure that it's terminal, you're really dying, with the fact that you could live? And is there sort of any ethical issue at that stage for prescribing a patient an RX when there's a possibility that they may actually survive? How do you reconcile those things?
This is a great question. Doctors aren't able to exactly say how long a person is going to live. But as I mentioned, in these individuals, the vast majority of them are very, 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 very sick and are seeing 2 doctors, usually a third doctor. They usually have a medical director of a hospice is also involved in their care. So there's quite a whole host of them. If you read Atul Gawande's book, the sad news is that for the most part, doctors over-predict how long a person is going to live. And the worst group is family doctors. So studies have shown that by as much as 500%, we predict that people will live longer than they actually ever do. And my group, I'm a family physician, are the worst at predicting a person's length of life, and it's actually the opposite. We think, and I think you're going to live longer than you actually are. So if a doctor is not confident or sure that this individual has that diagnosis, a prescription should not be written. It's not pure science. But these are people that, in my experience, I did have experience with patients. I have written end-of-life medications. All of these people were so sick, there was no question, and a couple of them didn't even make it to the 15 days. So it's not perfect science. I think you, as a California Medical Board, are charged to have licensees who are educated, who understand, and who can do the best that they can to protect the citizens of the state. So they shouldn't be making predictions of end-of-life care, if they aren't sure about it.
Thank you. Mr. Warner.
First, I've had more experience in this issue before the change in the law than I should have, being one of those public members that you talked about rather than a medical member. And I want to thank you for coming to give this presentation. It's very helpful. But my question is basically, are there any mistakes in our law or the Oregon law that the board should be aware of that we need to inform doctors of that there might be traps to fall into?
As I have to be careful. I'll take off all my hats now. Just speak for myself. I'm not speaking for Oregon Medical Board or Compassionate Choices, just in my own personal experience. The inability of citizens of Oregon to access this law in some areas needs to be looked at, and it really is sad that someone is suffering a horrible, terrible end-of-life situation, and it's legal in the state, but they can't find any source. Should be looked at in some way, and I don't know if that would be this law or another law, but that's the sad thing. It's very rarely used, but the people that need it, who are autonomous, independent, and suffering in such a horrible way, and then they do something more tragic. That would be one thing that I would say. In your California laws is pretty much the same as the Oregon law. I don't think there's too much difference. Main thing might be the independent word. In California, you have that independent word, right? And so I practice in a little town of Philomath, a town of about 2,000. I was there for 35 years. There were 2 doctors there, me and my practice partner. And we had some very, 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 very sick people dying, and might want to consider this. If they lived in California, if Philomath was in California, they would, according to the independent word, they would have to go to a different town to find another doctor. They couldn't talk to my practice partner about it. So I understand why that word was put in the California law, but it bothers me a little bit because I just think about the dying person who it's hard for them to get in the car and go to another town and find another doctor. But that's what's in your law.
Thank you. Dr. Kraus.
Thank you very much for this presentation. It's most valuable. To your knowledge, in any of the states where these laws exist, has there ever been any kind of untoward outcome of proper application of the law?
So do you mean that the person, when they took the fatal medication, didn't die?
No, there's a long list of possible untoward outcomes. It could be an agonal death, could be misuse of the medication by others, could be a inappropriate decision. So anything that could be viewed as untoward, to your knowledge, has that occurred in any of these states?
Well, certainly, there's been 6 in Oregon over the 18 years, and those were years and years ago. There were 6 individuals who took the fatal medication and did not die, and each of those was looked at, and it was discovered why. It was not taken appropriately, or it was taken in association with dairy products, or they had major use of laxatives. So I do know about Oregon more than anywhere else, and there's been no other misuse of medications, abuse of medications, coercion. There's never been any evidence for that. Recall then that these individuals are 19 out of 20 times are in hospice, and they are very connected. I mean, they have a social worker and a chaplain, a nurse, medical director, 2 doctors. So these are not people that are sort of out there that you don't know about them. They're very everything that happens to them is sort of documented somewhere in some AIDS log. So with the exception of the fact that early on there were cases of what's called awakenings, that's the only one of the things that I know of.
Yeah, Dr. Lewis.
Yes, a very, very informative presentation in an area that I think we all try to get our hands around, but don't quite understand what to do. There's lots of comments with, we got to dinner and about the law, and you're concerned about abuse, and maybe you just need 2 physicians, and are you going to put many, into this program, and you just need 2 doctors. So, but it was comforting for me to hear that most of these people are in hospice.
Well, thank you for asking that question. Again, I'll speak for myself. I think it's because we doctors think about ourselves and we're not listening to what our patients, their needs are. That had happened in Oregon originally, and we've seen a sort of a slow change where initially the Oregon Hospice Association was opposed to our Death with Dignity Act, and now they have a neutral stance. Initially, the Oregon Medical Association was opposed, and now, like California, they have a neutral stance. There were hospital associations, like the Adventist Hospital Association was opposed, did not allow their doctors. Now they do. Their Cascade Hospice, Benton Hospice, Evergreen Hospice now allow their employees to participate. So you're seeing a change. There's been a real kind of a change in Oregon, and but that isn't like a slippery slope. It's not like it's what it really is more people being realizing that as we advance our technology and get our patients these wonderful cures, they end up having 17 more things wrong, and then they end up having these situations where there's no dignity left in life. They're having intolerable suffering. So I am disappointed to hear that there are big organizations in your state that are saying that their doctors may not participate, and yet what I think you'll see, if it's like Oregon, is that they more and more will participate, with the exception of the religious ones. And if there is, in my opinion, again, an argument against medical aid in dying, that's valid. It is a religious argument that is absolutely valid. But other arguments for me, having taken care of patients having intolerable suffering and listening to them and caring for them, I believe that your new act is safe and appropriate.
Thank you. Dr. Grube, actually, I think my understanding is California Hospital Association is advising its members to stay off. But remember that California is one state where physicians cannot be directly employed by the hospitals unless they're a public entity like federal, state, or county. So and most of this, the one you're talking about, is outpatient stuff anyway. It's not within the hospital. So that's the difference between Oregon. My understanding is can employ doctors. Am I correct? Hospitals.
Yes.
Yeah. So
they do.
So that's the difference between California and Oregon. It was actually came up our own hospital executive committee meeting, and our understanding was that hospital is not willing to participate, but physicians in independent practice can do outside the hospital. So
it's almost, I would say it never has happened, but I would say it's almost never happened that a person has chosen aid in dying in Oregon in a hospital. Right. It just doesn't happen. Right. The final thing I forgot to mention, and I left Ms. Kirchmeyer a couple of these brochures, we have a program called Doc to Doc, and so any doctor in California can call a 1-800 number and ask a doctor from Compassionate Choices, and usually it's me, questions about that. And I wanted to assure you, and Ms. Kirchmeyer asked me about this, if there's any questions from a California doctor, a licensee that you're responsible for, calls me and is giving me information that I feel would violate the California Medical Practice Act, I would notify the California Medical Board immediately.
Thank you. Any other questions? Any public comment on this item? Any comments on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you. Thank you, Dr. Grube.
Thank you very much. Thank you.
Now we go to agenda item 5, President's Report. As you know, Mr. Serrano Sewell, the President of the Medical Board, was precluded from attending this meeting due to long-standing commitment. Therefore, I am providing the President's Report. Knowing that he would be unable to attend, Mr. Serrano Sewell provided a written report to the members. It can be found under tab 5 on pages BRD 5.1 and 5.2. Some of the highlights of this report include a few of the board accomplishments over the last 2 years, including the board's legislative day, which I had the privilege of taking part of. On May 11, 2016, myself and 7 other members visited several Senate and Assembly members to educate them on the board and its roles and functions. Several of them agreed to provide outreach about the board to their constituents via social media and websites. I would like to thank the members for their participation. Mr. Serrano Sewell in this report also asked about his 3 top priorities, which included interim suspension orders, a physician health program, and public outreach. We will have updates on each of these items today as well. Finally, Mr. Serrano Sewell discussed the patient notification task force and how the board will move forward on the issue of patient notification of the physicians on probation. More information will be provided by the board's executive director during her report and is also in her written report. Please know that board takes this issue very seriously and will take up different issues and ideas that have come from the task force in the appropriate standing committee. Regarding board committees, Mr. Serrano Sewell thought that it would be prudent to wait the election of the new officers prior to assigning members to any of the committees. The new board president will work with Ms. Kirschmeyer to review committees that need appointment and will make appointments within the next month. If any member is interested in certain committee or changing committees, please let Ms. Kirschmeyer know. Over the last quarter, Ms. Serrano Sewell and I have had a call with the board staff to discuss issues and projects at the board as well as the board's agenda. Are there any questions or comments from the board members on President's report from the board members? Seeing none, any public comment from the audience? Any comments on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you. So now we'll go to the agenda item 6, board member communications with the interested parties. Any board member has any? Oh, that's quiet. Thank you. Any comment from the audience? Any comment on the phone?
Do we have any comments?
We have no comments from the phone lines.
Oh, we are cruising along. The next item is agenda item 7, executive management report. Ms. Kirschmeyer.
Good afternoon, members. I'm not going to be going over the administrative summary, the enforcement program summary, or the licensing program summary unless someone has a question. However, I do have a few things I'd like to point out and bring to your attention. I'd first like to draw the members' attention to page BRD 7A5, which is the governor's budget that passed in June and includes the medical board's budget basically for fiscal year 16-17. On that page, on page BRD 7A6, the board's fund condition indicate that the board's fund reserve is projected to be at 3.6 months at the end of the last fiscal year and below the mandate in fiscal year 17-18. The board has not received month 13 reports yet, so it has not been finalized for fiscal year 15-16, including actual final expenditures that will come in October. Once this is completed, it will identify where the board's fund reserve is at the end of this past fiscal year. I'm happy to report that the board's budget change proposals to hire an additional staff in the central complaint unit and to increase our expert reviewer funding was approved and included in the governor's budget. Staff is working to hire this new position in the complaint unit. The fund condition on page BRD 7A6 also identifies the other BCPs that were approved and shows loan repayment of $6 million in this next fiscal year. As we've done in the past, on pages BRD 7A 18 to 19 is an update from the executive officer of the Board of Pharmacy. Yesterday, I also gave a medical board update at the Board of Pharmacy meeting. We will continue our collaborative efforts and will continue to update each other's boards. And I'll be providing more information on this under agenda item 8. I would like to draw the board's attention to 7B 8 to 13. This has been a long-standing issue, and I am so happy to report that our information technology staff has finalized the requested enforcement reports and has included the information from these reports on those pages. In addition, as promised, the staff has updated the vertical enforcement reports since the reports were placed in the vertical enforcement report released in March. Those reports are on page BRD 7B 14 to 17. All of these reports will continue to be reported from here on a quarterly basis at each board meeting. I would like to point out that the board staff tried to use the same data markers for the reports from the CAS system, which was our old database system, to the new one, the Breeze system. However, based upon the chart on page BRD 7B8, and if you look at that one, you'll see a large jump. I'm not sure that these reports are actually comparing apples to apples. I believe that may be one of the reasons for the increases in time, but we also know that there's been an increase in the number of complaints and the transition to the new system. So we do know, and that's one thing that Ms. Delp spoke about in the enforcement committee, that they're doing overtime to help on that time in that central complaint unit. However, the reports are gathering information we want to show, and that is the time in that central complaint unit from the time a complaint's received until the time it is closed. And therefore, we're going to continue to use these reports, but the starting point might be the best thing to use when we first got this new report and go from there rather than looking at that old data. The difference in the report on page 9 versus those on 10 or 11 are due to the fact that we now want to measure the investigation process separately for sworn staff through the Health Quality Investigation Unit and the time it takes for them versus the time for the non-sworn staff at the medical board. So that's why you see the separation out. So it looks funny because we only go through, I think, October or through 13, 14, and then we stop and it goes to those next two pages. So that's the difference. And from here on out, we're going to just be capturing non-sworn and sworn staff. So those pages will look like that from here on out. In addition, we also now have the information that indicates on page 12 the length of time it takes to file an accusation. We definitely know that this report is actually not comparing the same data pre and post Breeze, because we can now look at cases that are truly AG referrals for an accusation, as to where in the past, when we were looking at it under the CAS system, we actually looked at those also that went for a public letter of reprimand to the board for processing. So these reports truly are just Attorney General time. So that's all of the information on those enforcement charts. That's the first time, and we will be sending those, providing those now on a quarterly basis to the members so you can kind of follow how the enforcement program is doing. A notable statistic for the licensing program is the fact that the board issued 222 more licenses in this fiscal year than the prior fiscal year. In addition, if our numbers are correct, and this is one we're still verifying the information on, it appears that we received 913 more applications this year than in prior years, and that's a huge jump for us. So that's it on all of those reports. I'm going to move into the CARES update unless there's any questions. Okay. In regard to CARES, I want to let the members know that the board really made a push at the end to get individuals registered. We sent weekly emails to physicians who had not registered and even had a countdown clock on our website. Hopefully you all saw that. It was something we stole from the pharmacy board. We received a significant amount of calls the 2 weeks leading up to July 1st, but staff assisted where they could and contacted DOJ in order to assist those that we could not help. As of Monday, there are 71,491 individual physicians registered in the CARES 2.0 system. In addition, there are approximately 32,000 prescribers and dispensers who were in CARES 1.0 but have not updated their information, so we can't identify whether they're a physician or they're another prescriber or dispenser. So that number of 71,000 is actually higher even than that number. This really shows that the outreach by the board and all interested parties really had an impact, and I want to thank the California Medical Association, who also made a push in those last few days to get people registered. I'm currently working with the Department of Justice to identify physicians who have a DEA to prescribe but are not yet registered. Once we identify those physicians, we will send an email and possibly a postcard to them informing them that they need to register into the CARES 2.0. In our most recent newsletter, we also published a FAQ section based upon some questions we were receiving from the calls on CARES. And just to give you an example, we actually got several patient calls that came in that said their physician told them that they were no longer going to be prescribing after July 1st because they had to register in CARES. That's how much information, misinformation is out there, because I think that the doctors were scared that, oh, now I have to register and now my prescribing is visible. Well, their prescribing's been visible since 1999. It's just now that you can actually, as a physician, get in and see it. So we're trying to nip some of those questions by putting out this FAQ in the newsletter. Another interesting statistic I wanted to pass on about cures is that from June 25th to July 25th, physicians requested 161,499 patient activity reports. So kind of think about that. In 1 month, over 161,000 patient activity reports. So I do think that registration into cures has made a huge impact on the doctors who are actually now using it. As I stated at the last meeting, the board is working with the University of California at Davis and the Department of Justice to send a survey regarding the Cures 2.0 system to all physicians whose licenses expired in November. So they're coming up. The survey will be attached with their November renewal that will be sent out next month. The survey is going to ask physicians how Cures 2.0 is working for them and any problems they are having, as well as any suggestions for improvement. Again, this survey is part of a study on opioids and part of a grant work being done by the California Department of Public Health and the Department of Justice. Are there any questions on the cures? Okay, moving on. I'd like to draw your attention to pages 7E, 1 to 15, which includes not only an update from the Executive Director of the Health Professions Education Foundation, but also the Stephen M. Thompson Loan Repayment Program Annual Report. So since we don't have Dr. Yip is no longer on that board, or on that program, we're actually doing a written report, and again, in Sunset, we're going to try to get medical board members back on that education foundation. Regarding the issue of overprescribing psychotropic medication to foster care children, I'm happy to report that the board received additional information from the Department of Healthcare Services and Department of Social Services on June 13th. That additional information was not exactly what the board had requested based upon our expert's review and her request, but it was the information that they had available in their two systems. The additional information has been provided to our board's expert pediatric psychiatrist. The board is hoping to have a response from that expert in August. We're hopeful that that additional information will allow the expert to identify if there are any physicians who are inappropriately prescribing, so the board can continue through the enforcement process and obtain medical records. And also regarding that, as all of you know, our mantra, and Ms. Somoza and I, in any meeting that we attend regarding this issue, our mantra is that we need to have complaints from those who are in the system. The social worker, the nurse, the public health advisor, all of those individuals that are in that system, if they see an individual who's inappropriately prescribing, we really want them to prescribe. In that regard, recently, Ms. Delp has actually attended, and will be attending actually in the future. We requested to be on the agenda. She did a really good job pushing for this. So she's going to be doing a 10 to 15-minute presentation at the next Quality Improvement Project meeting on our enforcement process and how to make a complaint. And we've actually done a shortened version where individuals in that system can actually call her and Ms. Romero and make a complaint rather than having to go through the whole complaint process with the documents that we have. And so we're going to be talking about that. And again, it's just to encourage those in the system who truly see these individuals who are inappropriately prescribing so they can make a complaint. One Breeze update I would like to bring to your attention is that as of yesterday, the ability to subscribe, actually it was done at midnight last night, so it was starting this morning. The ability to subscribe to a change in a licensee's primary license status was turned on. This means that an individual can go into Breeze and sign up to receive a notification when a licensee's primary status is changed. So for example, if your physician's status went from renewed and current to revoked, the Breeze system would send that subscriber an email saying the status has changed from renewed and current to revocation. This was something that came up during our discussions on the patient notification. I also wanted to let the members know that, as most of you know, Hetty Chang in the past had been our FSMB representative, and then it changed to Dr. Watson, and now we have actually changed to Dr. Steingard, who is from the Arizona Osteopathic Medical Board, and he actually is going to be our new liaison. So that's the only update really I have on the Federation. Lastly, as Dr. Gonadev stated, I would like to draw the members' attention to pages 7A, 3, and 4 regarding the Patient Notification Task Force. After discussions with the board president and vice president, it was determined that the issues from the task force will be pursued under the appropriate standing committee. The information regarding these issues are listed on the 2 pages, but I'm just going to summarize. The outreach and website changes will be pursued within the Public Outreach, Education, and Wellness Committee. The signage and changes in legislation to allow the board to require more information that on the sign a physician must post will be pursued through the board's sunset report. And lastly, the issue of a possible change to the disciplinary guidelines to have an optional condition that would require a physician to notify their patients they are on probation will be studied under the board's enforcement committee. While the change to add this condition to the guidelines can be done through the regulatory process, the mechanics of how that notification would occur is something that needs to be looked in and fully discussed with all interested parties, because as you know, that was a lot of the concerns that were brought up by everybody in the room on this issue. That concludes my report. Are there any questions?
Thank you, Ms. Kirschmeyer. Any questions from the board? Any public comment? Any comment on the phone?
Do we have comments on the line?
Yes, we turn to the line of Genevieve Clarborough. Please go ahead. Your line is open.
Sorry?
We have a call.
Go ahead.
Genevieve, go ahead.
Oh, Genevieve, okay.
And Ms. Clarborough, you might have your phone on mute.
You ever met Genevieve? I don't think you've seen Genevieve. She wasn't here last time. Genevieve's quite a character. She's a regular.
Genevieve, are you there? What's going on?
Hello.
There you go.
Hello.
Yes, it's about a statement about cures. I think some of the physicians are not very skilled at using it, and yes. Yeah. Anyway, I had issue recently. I'm not going to discuss it because I sent you a. Yes. Can you hear me?
Yes, we can hear you.
Can you hear me?
Yeah, we can.
Yes. I think a lot of the physicians still don't know how to use the cure system well. Anyway, I have sent you a formal complaint, so I'm not going to speak on it now, but I think it's still an issue on how skilled some of the physicians are to utilize cure.
Thank you.
Thank you, Genevieve. Actually, we miss you. Take good care of your health.
Yeah, I'll send it today. Okay. Have a good day. Thank you for listening.
Thank you.
Any other comments on the phone?
Any additional comments on the line?
We have no further comments in queue on the phone.
Okay. Thank you. And moving to agenda item 8, discussion on collaboration with the Osteopathic Medical Board of California, Board of Registered Nursing, Board of Pharmacy, and Physician Assistant Board. Ms. Kirschmeyer.
So this one will be a lot shorter. At the last meeting, a member requested that board staff look into meeting with the Board of Registered Nursing and the Board of Pharmacy on issues of mutual concern. This collaboration is very similar to what is occurring at the national level. At the national level, they are looking at successful team building, new practice models, and communication ethics. And as you all know, there was a tri-regulator meeting between the National, the Federation of State Medical Boards and the National Association of Nursing, or Nurses, and then also the National Boards of Pharmacy. So while thinking about starting this collaboration, I determined that we should not only be meeting with the boards of pharmacy and registered nursing, but also the Board of Osteopathic Physicians and the Physician's Assistant Board. In several states, these licensees are all under one board, but that's not the case here in California. This is a great opportunity to bring these boards together to work on issues that impact each one of us. I've already reached out to the executive officers of each of these boards, and they're all very excited to meet. I'm in the process of setting up meetings with the executive officers in August. Some of the issues identified which to discuss are collaborative care, telemedicine, CARES usage, and the opioid epidemic. Once we get the discussions going, it may be valuable to have 1 to 2 board members from each of the boards also get together. I think some outcomes of the group could be education on certain issues and a united front on issues such as the opioid misuse and abuse. Once the initial meeting takes place, I'll provide the members with an update. This is a very exciting endeavor, and the director of the Department of Consumer Affairs has also offered to attend and assist in any way necessary to move this collaboration forward. This is a partnership is very important in the era with telemedicine and technology and medicine both evolving. And again, if you're interested in being on that collaborative, I'd really appreciate you to let me know, and I can discuss that with the new board president. Working together would also lead to enhanced consumer protection. Are there any questions on that?
Thank you, Ms. Kirschmer. Actually, this came about when 3 of us attended the FSMB meeting in San Diego, and Ms. Kirschmeyer were there with the states where they're doing. There was some significant collaboration. We thought that would really help working together with all these boards. Thanks for looking into it. Any questions from the board members? Any public comment? Any comments from the phone?
Do we have any comments on the line?
Yes, we do. We turn to the line of Genevieve Clibrell. Please go ahead. Your line is open.
Yes. Please, I would like to be kept informed of that the team approach. I have been very involved for a long time, and I would like to be one of the members of the public to be involved in it. So please keep me posted. Thank you.
Thank you.
Thank you.
Any other comments?
Any additional comments on the line?
We have no further questions in queue.
Thank you. Moving to agenda item 9, update on the sunset review process. Ms. Kirschmeyer.
On July 8th, the board received its Sunset Report questionnaire. That document can be found on pages BRD 91 to 15. Per the memo from the legislature, this process allows the legislature to review the laws and regulations pertaining to the board and evaluate its programs and policies, to also determine whether the board operates and enforces its regulatory responsibilities and is carrying out statutory duties. It's also there to examine fiscal management practices and financial relationships with other agencies. Boards are also evaluated on key performance measures and targets related to the timeliness of action, enforcement, and other necessary efforts to serve the needs of California consumers while promoting regulatory efficiency and effectiveness. The report form must be completed by December 1st of 2016. And just to give you an idea, I don't think it will be like this year, but in the past, the last time we did it, our document was 4 volumes, and each volume was about a ream of paper. So we have a lot of work ahead of us, everyone. The first sections of the report provide an overview of the board's current regulatory program, and the latter sections focus on responses by the board to particular issues raised by the board or raised during the Sunset Oversight Review. The report serves as the basis for the background paper legislative staff will prepare. The board was informed that the Senate Business and Professions Committee will announce the dates for Sunset Oversight Review hearings in early 2017. Board staff has put together a matrix identifying who is responsible within the staff for the questions within the report and their due dates. Ms. Robinson, who spoke earlier today, will again lead the drafting and compiling of all of the information in order to complete the document. One of the hardest parts of completing the report is the writing and compiling of statistics required for the report. So our information technology unit is going to be working with us to get all of the reports we need, because if you look at that, you'll see a lot of the charts are very specific statistics. I'll be working with the board's president to identify a 2-member task force to assist staff with the completion of the Sunset Review report. If anyone is interested in assisting, please let me know as soon as possible. While we hope to be able to present a draft at the October board meeting, it may be necessary to hold a November teleconference meeting to finalize the report due to the lateness of the receipt of the report and the later due date. Since the report was done just 4 years ago and several of the questions just need updates from the last 4 years, this may not be necessary. We may want to provide we do want to provide the members with as much possible time to review the report and to provide comments. It may also require, if we don't do the one in November, it may require us to do a afternoon in the October meeting, a Wednesday afternoon, to review the report. I don't know that that's going to be necessary, though, because we've actually already identified the new issues and you've already approved those to move forward. And our last time, what took a lot of time is going through each of the new issues and identifying whether we wanted to do them or not. So you've already done that. So we're already ahead of the ballgame on that one. Staff will work with the board president on the details of this review process. Are there any questions? And again, I really am looking for 2 individuals who really want to be committed to this report and help us walk through this so they can kind of be our eyes and ears of the board prior to it bringing it to the full board.
Thank you, Ms. Kirschmeyer. Any questions to Ms. Kirschmeyer? Any public comment?
You have one public comment.
Okay. Carol Moss.
Hello. I'm Carol Moss, and I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across the country, in California and throughout the nation. We recommend that the board raise the following issues with the legislator as part of the Sunset Review. Review process, improvements to patient safety in outpatient surgery settings. Outreach by the board related to physician discipline needs change to the medical board's statute of limitations, and reports of actions taken by hospitals and clinics in the 805.01 reporting. Physician-owned outpatient surgery settings. Hundreds of thousands of surgeries are being performed in California at physician-owned surgery centers. When many outpatient surgery centers were brought under the purview of the MBC, of the medical board, due to a 2007 court decision, Capon versus Sharif, requirements for these surgery centers to report data regarding procedures to the Office of the Statewide Health Planning and Development were removed. We recommend that outpatient surgery settings under the medical board's purview will be required to report a standard and robust set of data to the Office of the Statewide Health Planning and Development. We also recommend this for settings outside of the medical board purview. Outpatient surgery settings are required by law to report adverse events to the medical board. The law authorizes the medical board to fine physicians who fail to report adverse events in a timely manner. We recommend that the medical board post on its website the adverse events reports it receives from outpatient surgery settings and any fines assessed. This information should be posted within the profile page of each relevant surgery setting. Current law says consumer groups and journalists who request hospital adverse event information from the California Department of Public Health may have it. Consumers Union and other media outlets have regularly requested and received this information. We recommend the medical
Please
board do the
conclude.
same. We recommend the medical board do the same in outpatient medical settings. Revise signs in doctors' offices. We ask that you add notification of the phone number of who the medical board is and how they can be reached. Many patients don't know that you're the governing body. We also ask that there's a statute of limitations on filing. We know that the statute of limitations on filing complaints against doctors are greatly affected, and we ask that even cases where the medical board has found extreme departure from the standard of care can be closed, allowing physicians who have violated their licensing standards to continue to practice. So we asked you to review that as well. We thank you for consideration, and we appreciate all the work that you guys are doing. We're really excited to see what happens in the coming year.
Thank you, Ms. Moss. Any other public comment? Comments on the phone?
Do we have any comments on the line?
We have no comments on the phone lines.
Thank you. Let's go to item 10, update from the Department of Consumer Affairs. Ms. Lally. We'll be nice to you, Christine.
Promise?
I have a breeze update. Good afternoon, Vice President, members. Thank you again and always for the opportunity to be with you. Christine Lally, Deputy Director of Board and Bureau Relations with the Department of Consumer Affairs. Want to update the board on several important items since our last, your last meeting in May. First, I'd like to update you on changes to the department's executive team. In May, as you may remember, after 18 years, I aged her 8 years with the department. Tracy Ryan, our Chief Deputy Director, accepted another position with the Rural County Representatives of California. Then in late June, Governor Brown appointed Jeffrey Mason as our new Chief Deputy Director. Jeff has been with the department since 2013, serving as Chief of the Bureau of Security and Investigative Services, and most recently he served as the Chief Deputy Commissioner for the Bureau of Real Estate. Jeff was sworn into office just 2 weeks ago, so he's in his third week on the job, and we're very excited to have him on board. Also in May, Melinda McLean, as you also may remember, was our Deputy Director for Legislation. Melinda went on to accept a new position with the governor's office, so we're very proud of her. And just last week, again, the governor made an appointment of a new Deputy Director for Legislation, and that's Adam Quinones. You may remember his name because he previously served as the Assistant Deputy Director for Legislation for the department, and he worked very closely with Melinda. So we're very excited for both Jeff and Adam in their new positions at the department. Next, wanted to update the board on some organizational development at the department. As you may know, the department's Solid Training and Planning Solution Unit is specifically dedicated to the department's organizational development and offers a wide array of services to all of DCA's boards and bureaus. Solid recently hosted its second Executive Officer Brown Bag Gathering, and that happened on July 20th. These meetings provide an opportunity to strengthen networking among the department's executives, as well as time to discuss cross-cutting issues and receive peer input on challenges faced in the workplace. It also provides us at DCA a chance to solicit feedback on what other leadership development activities we can provide our executives. Feedback from the executive officers participating at the first two Brown Bag gatherings has been very positive, so we're hopeful on this new program. Also at last week's gathering, the department introduced a new program we are very excited about, and that's our Future Leadership Development Program. We believe it's critical to enhance the skills of our next generation of executives at the department. This program has 3 components. First, it specializes in training. Second, mentoring opportunities from the DCA executive team as well as other executive officers. And finally, a group project designed to assist boards and bureaus in addressing common challenges. The group project gives staff the ability to build new skills and knowledge, as well as interact and collaborate with high-performing peers from other boards. There will be a steering committee of executive officers that will assist the department with this new program. Again, we received valuable feedback from those in attendance at last week's meeting on this new adventure that we're both working on, and we look forward to implementing this program together by the end of this year. This new program is an excellent example of how the executive officer Brown Bag gatherings are already providing us unique opportunities for collaboration to address needs department-wide. The department has also officially launched the Employee Career Empowerment and Mentorship Pilot. This pilot, Mentors Submit, and Kim's smiling because she's helping us with it, thank you. Mentors submit profiles that include short biographies, their availability for mentorship, and topics that they're willing to discuss. Our Solid team posts the profiles on the department's intranet, and staff review the profiles and schedule meetings with the mentors. The pilot affords staff a great deal of flexibility to learn from various participating managers. In early 2017, our SOLID team will conduct an evaluation of the pilot to look for possible improvements and determine whether we should expand it. There are currently 8 DCA boards and programs participating in this new pilot, and again, we want to thank Kim and her staff for being one of them. Also, on the employee front at the department, in an effort to complement the mentorship pilot, our SOLID training team has also developed the Lunch and Learn class series. This is a new component of the DCA Connect training series to encourage our staff within various classifications to engage one another on interesting topics. The sessions are held once a month during 1-hour lunch breaks. In a roundtable setting, DCA employees learn from one another through active listening, effective communication, and understanding another's viewpoint. The facilitated conversations have been engaging, informative, and from what I hear, very lively. Topics have included what does professionalism mean to you, and change your perspective, change your life. We again thank the medical board staff for participating in the Lunch and Learn series. The next meeting is titled Honoring Cultural Diversity, and it is scheduled for August 25th. The SOLID team is obviously very busy, but they're also specifically helping Director Kadani and the executive team to develop our new strategic plan, which will span the years of 2017 through 2019. I wanted to bring this to your attention because we will be soliciting input from stakeholders, including all of our board members, executive officers, and all employees at the department to help us identify the department's goals for the next 2 years. An electronic survey from the department will be sent out to all of you and all stakeholders in late August. Your feedback is vital, and we respectfully ask for your participation to assist us in improving the department's services and ultimately our oversight. Finally, I always leave our favorite topic to the end. I wanted to quickly just give you an update on the BRIES system and specific statistics pertaining to the board, as I know you're very interested in always hearing about how the BRIES system is performing. The medical board continues to see a high volume of applications submitted online in May and June, and unfortunately our IT team doesn't have the statistics for July available just yet, but the board in the 2 months of May and June, the board received over 8,886 applications online. For applications requiring a payment, this represents approximately 58% of the total board application volume for this period. Renewals continue to make up a majority of the board applications received online. 8,251 were received in May and June, and of those individuals who renewed online, 98% of them renewed the very same day. So that's incredible efficiency. As of this week, the department has processed over $208 million via the BRIES online system since the Med Board and the first 10 boards went live in October 2013. Since go live specifically for the medical board, you have processed over $100 million via the online BRIES portal, so congratulations. Next, wanted to touch base just on the maintenance releases, which Kim just updated you on, and that's a great improvement on the notification, the subscription. But for calendar year 2015, so last year there was an average of 73 fixes that were deployed in the BRIES scheduled maintenance releases. And since the launch of Release 2 onto the BRIES system, which was earlier this year in January, an average of 167 fixes have been deployed in each scheduled maintenance release. And this is more than obviously double than the average rate from last year. The scheduled maintenance releases occur every 6 to 7 weeks for the boards and bureaus on the BRIES system. And a maintenance release of 161 changes, including the one that Kim updated you on today, 161 changes occurred just yesterday. The next scheduled maintenance release will happen in September. And finally, just wanted to update you on the Breeze License Lookup Survey. The department is currently conducting a survey to collect public feedback on the Verify a License feature that's available on the Breeze page. We encourage the board and board members to share this survey with your stakeholders, as we definitely want to get a diverse set of participants to assist the department in determining potential updates to the Verify a License feature in the Breeze system. This survey that we're conducting started on June 1st, and it ends on August 31. As of this week, we've received approximately 5,000 responses to the Breeze Lookup Survey. And the way you can get on it too, if you go to the Breeze site and do a license lookup, you'll get a random selection to participate in the survey. So if you do it enough, you should, it should pop up. Comments received thus far have been very positive, and they're providing constructive criticism, which I know our vice president has been very vocal on wanting to update the Verify a License page. So with the board's help, as well as feedback from the survey, we hope to have a good consensus of the changes that, you know, would be helpful to the public in updating that page. So that continues to be a high priority for us. So with that, I will thank you again for the opportunity.
Thank you, Ms. Lally. 98% is just amazing. I mean, it's not that we're tired of complaining about it, but actually there are no anecdotal reports from me, doctor coming and telling me that he or she can't renew their license, they are stuck. That used to be a very common practice before. I haven't heard that in the past few months.
That's excellent. Good.
And I hope that the same thing the consumers can find for looking up their doctors and really see wherever they need to go. I think that's plus one major advantage we'll have with the system when it finally looks like bugs are we're taking care of the bugs. You can do so much research. It's unbelievable amount what the European country people present at the national meetings, what they can do with their with the physician licenses, what's the percentage of probations and revocations, all kind of stuff, which is difficult for us. It's a manual thing right now.
Mm-hmm.
Any comments or questions to Ms. Lally from the board members? Oh, Christine, you're going getting off easy. Any public comment? Any comments on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you, Ms. Lally.
Thank you.
Okay, we go to item number 11, update, discussion, and possible action and recommendations from the Enforcement Committee. Dr. Yip.
Thank you. We met this afternoon at 1:20 p.m. Ms. Dell provides serious enforcement update. Training with the Office Administrative Hearing will resume this fall with training to be held in September, October, and November regarding emergency room procedures, comorbid patients, and fitness for duty evaluations. At the conclusion of the training, the board staff would provide 6 training sessions to the administrative law judge. Ms. Depp also reported that the Central Complaint Unit has decreased the average number of days to process a complaint from 162 days to 146 days, and management continues to identify ways to streamline the complaint process. Ms. Depp also reported the enforcement program currently has 6 vacancies, and efforts to hire new staff are ongoing. The vacancies are expected to be filled by September 30th, 2016, right? Ms. Robinson gave an update to the demographic study and reported that she and Ms. Kirkmeyer met with the California Research Bureau's senior policy analyst who is conducting the study. The analyst informed Ms. Robinson and Ms. Kirkmeyer that the Bureau will be ready to present the findings of the study at the October board meeting, and one of our committee members, Dr. Krause, has been actively involved with that. Ms. Depp gave a presentation on what recruitment efforts staff in the expert review program are doing to recruit more experts. Ms. Depp provided a 3-stage plan that includes updating the board's website and newspaper, as well as creating a recruitment brochure and public service announcement videos to entice more physicians and surgeons to participate in the program. Ms. Delp also stated 2 expert review training events are tentatively scheduled for October 8th at UC San Francisco and November 5th at the UC Los Angeles. I'm also trying to set the date in the spring with the USC in Southern California, sometime in March, April, and May. Ms. Castro from the Attorney General Office Health Quality Enforcement Section gave an overview of the vertical enforcement process, and we're pleased to hear that her staff worked tireless overtime and with passion and low pay too. Mr. Chris and Ms. Nichols from the Department's Health Quality Investigation Unit gave an update regarding what efforts HQIU is doing to hire more sworn investigators. To mitigate the vacancy issue, HQIU will be hiring some non-sworn investigators and investigation assistants to handle the less complex cases, and psychology and osteopathic board cases will be investigated by the staff in the Investigation Enforcement Unit on a temporary basis until the vacancies are filled. Lastly, Ms. Delp and Ms. Houston give a thorough presentation about the actions probation staff takes when a probationer violates a condition of his or her probation and the time frame for staff to act on the violations. Enforcement committee members, which I'm lucky to have, both are very committed and smart. Dr. Boland and Dr. Krause state they would like to see as a future agenda items the presentation on the quality indicators and quality assurance efforts, a measure of how we improve on the process regarding the actions taken by the probation staff to act when a violation of probation is identified. So that concludes the meeting today.
Thank you, Dr. Ip. Any comments? Yes, Ms. Wright.
I think this might be appropriate within the purview of the Enforcement Committee before I bring it up to the full board, but understanding that the Medical Practice Act says that our primary purpose is public protection, I heard at least 6 people speak on SB 277 today, and one of the comments was that potentially doctors are getting kickbacks from insurance companies to do a workaround to still give an immunization to children who aren't supposed to have them. I'd be interested to see if we can get someone either from Senator Pan's office and or if staff could look into these accusations, because if so, that seems to me that there would be a serious ethical violation. But at any rate, I would still like to hear someone from Senator Pan's office come and speak to some of the issues that we heard raised by some of the public members as it relates to some of the health concerns that they have in terms of history of their children and the immunizations. And I think it was Santa Barbara that has some kind of process that they're using to work around that. I would like to see that. If it's not in the Enforcement Committee, then at the public, at our full board meeting. Emphasis on Senator Pan's office coming to our meeting, since we did, as a majority of the board, decide to support this, minus the 2 abstentions.
Thank you, Ms. Wright. Any other comments? Public comment, I have one. Carol Moss. Ms. Moss.
Thank you again. Yes, my name is Carol Moss, and I'm here again with the Consumers Union Safe Patient Project, nationwide campaign that's organizing patient safety throughout the U.S. and in California. Earlier today, we presented the same discussion here to the Enforcement Committee on the recommendation that the board amend these guidelines to require physicians on probation for serious issues to inform their patients of their probationary status. The presentation today was great on the things that are going to be coming up. So we think that this is very important. Unfortunately, many California patients have no idea. They're unknowingly receiving health services from physicians who have been placed on probation for a range of offenses, including substance abuse, sexual misconduct, violence, patient death, incompetence, gross negligence, and repeated negligent acts. When the medical board allows these physicians to continue practicing medicine while on probation, the physician should be notified. They should let their patients know so they can be aware of why they're on probation. Certainly, the patients also have the right to know, as the insurance companies and the medical board and the hospitals. According to the published research and the medical board's own data, physicians on probation are much more likely to require further discipline than physicians who were never disciplined. We also recommend that the patient notification requirement for physicians who are ordered on probation more than one time. We recommend that the medical board demonstrate its commitment to the patient safety by amending its disciplinary guidelines to require, as a standard condition, the physician whose probation is associated with a certain serious violation and practices restrictions be required to disclose their probationary and practice restrictions to their patients. In addition, to help people understand why the physicians have been placed on probation and to fulfill the medical board's stated principle that all consumers should know the history, the disciplinary action, and any healthcare provider they may consider seeing, the medical board ordered the summary. The summary should cover the causes, the probation, and including the accusations of those which the physicians is stipulated, the length of the probation, and all practice restrictions placed on physicians. The summary should also include in the first section the decision and order of probation in plain view, in easy language in Breeze in the webpage, and on any other medical board documents informing the public of probation orders and newsletters, including public records request. The medical board should also amend the current disciplinary guidelines that make patient notification an optional condition in all probation cases. The medical board should develop an effective process to ensure the enforcement of the disclosure of this requirement. And we thank you for all your hard work, and we look forward to seeing all the great changes next year.
Thank you, Ms. Moss. Any other public comment? Any comments on the phone?
Do we have any comments on the line?
We have no comments on the phone lines.
Thank you. The next item is item number 12, update from the AG's office. Ms. Castro.
Thank you. I'm happy to report we have a new Deputy Attorney General in our San Francisco office. His name is Keith Shaw, and he joins us from the Sonoma County District Attorney's Office. We continue to meet with Ms. Delp and Ms. Kirchmeier to find improvements in all of our processes. We really enjoy working with both of them and their respective staffs, and we have nothing but the utmost respect for them and all of their big mission that they have to accomplish, and they always do it with a smile. We look forward to assisting in any way that we're asked on the Sunset Review report as it pertains to our role in your enforcement and licensing functions. SB 467 has been enacted into law in Business and Professions Code Section 312.2, and it will require the Attorney General's office to file annual reports with the legislature regarding our performance metrics at the Attorney General's office following the presentation of any transmitted case. And this applies for all of our clients. And so the metrics that will be measured are filing metrics and subsequent averages for important milestones in the life of those administrative cases we do work. We welcome the transparency and accountability, and this report will actually apply to every single DCA client agency, commission, board, and it also applies to the licensing section in my office, which mostly handles non-health care related DCA client agencies, such as smog technicians. They do handle nurses, dentists, and veterinarians, but in contrast to our section, we're 100% health-related client agency work. Our first report will be filed on January 1st, 2017 for statistics related to fiscal year 15-16. So that started already in July 1st. With SB 467, the Attorney General's office joins the Office of Administrative Hearings in our mutually beneficial responsibilities in this whole process for consumer protection, and we welcome the metrics. And so now that we will have metrics from the Office of Administrative Hearings, together with metrics from the Attorney General's office, and of course, all the Sunset Review hearings and annual reports that you as boards and all of my other clients file, we will be able to see the true and full picture, nose to tail, so to speak. And with that, I conclude my remarks.
Thank you, Ms. Castro. Any questions for Ms. Castro? Any public comment? Any comments on the phone?
Do we have any comments on the line? Are there any comments on the line?
I'm sorry, there are no comments on the phone lines.
But they all went home. Thank you, Ms. Castro. Then we'll go to the next item, item number 13, update from the Physician Assistant Board, Dr. Bishop.
Thank you very much. The last board meeting occurred on July 11th. At that time, we introduced a new member who was appointed by Governor Brown, Jennifer Carlquist, and she has extensive experience in the physician assistant world, and we're appreciating her experience on the board. With respect to Breeze, a new online version of the PA application for licensure was added to Breeze in June 17, 2016. And in summary, this new licensing application has enhancements and features which will streamline the process for the applicants. With respect to cures, as we've talked today, all practitioners were required to register before July 1, 2016. In an attempt to achieve that with the PA board, the board updated the website with a cures countdown calendar and also sent a notification blast to our email subscribers regarding the cures registration deadline. With respect to the End-of-Life Options Act, Assembly Bill AB 15, which became effective June 9, 2016, the board developed an information bulletin for physician assistants regarding the act. The bulletin states the specific requirements of the End-of-Life Option Act and may only be performed by the patient's attending physician and not delegated to the physician assistant. The bulletin has been posted on the board's website. With respect to rulemaking to repeal Title 16 California Code of Regulations, Section 1399.531 and 1399.532. At the April 18, 2016 board meeting, there was general consensus that the board may wish to examine repealing Title 16 California Code of Regulations, Section 1399.531, curriculum requirements for an approved program for primary care physician assistants in Section 1399.532, requirements for an approved program for the specialty training of physician assistants. The board currently delegates authority to ARCPA to approve physician assistant training programs. Postgraduate specialty physician assistant training programs approved under Section 1399.532 provide training to licensed physician assistants to enhance their current skills. The board does not issue an additional license to individuals who participate in specialty physician assistant training programs. Additionally, since postgraduate specialty physician assistant training programs are training licensed physician assistants, and those students are subject to the same requirements as licensees who have not participated in a postgraduate specialty program, the board believes that there is no need to continue to approve these types of programs. After discussion on this item, the board voted to repeal Title 16 CCR Sections 1399.531 and 1399.532. With respect to Title 16 California Code of Regulations, Section 1399.540, subsection B, Delegation of Services Agreement, electronic signatures. The board continues to discuss the now widespread practice of the use of electronic signatures in patient records and other documents utilized in the medical environment. The board recognizes that electronic signatures allow for the more efficient use of medical practitioners, thus improving care. At the board's April meeting, members voted to request that staff develop proposed amendments which would include the use of electronic signatures in the Delegation of Services Agreement for possible initiation of a rulemaking file to amend Section 1399.54, subsection B. Legal counsel reported that they continue to research the use of electronic signatures to assist in drafting amendments to Section 1399.540. Although this seems like a simple process, it's very complicated because, especially in emergency departments, where a single physician assistant may be supervised by more than one attending physician. So it becomes very complex to make sure that this clearly identifies who the responsible physician is. At the meeting, there was a presentation by the Health Professions Education Foundation regarding scholarship and loan repayment programs. Norland S. Asprick, excuse me, Director of Marketing and Outreach for the Health Professions Education Foundation, which is part of the Office of Statewide Health Planning and Development, OSHPD, gave a presentation about the foundation and the scholarships and loan repayment programs offered to healthcare students and recent graduates, including physician's assistants. Pardon me, let me get some water here. Thank you. At a recent board meeting, it was noted that the state of Georgia recently passed legislation providing tax deductions for physicians who serve as community-based faculty physician for medical corps clerkship provided by the community-based faculty. In other words, physicians who served as a preceptor for the education of mid-level healthcare providers such as physician assistants. The board discussed the possible need for tax incentives for physician assistant preceptors. This clinical instruction may come from other PAs or physicians who are not generally paid for their time, but may receive CME credit for being preceptors. Therefore, it is often difficult to find healthcare providers to be preceptors because they are not financially reimbursed. To further explore this concept, the board will hold stakeholder meetings to determine if there's a need to seek legislation. And finally, once again, the PA board would like to thank the medical board, your executive officer, and staff for your continued support. The next scheduled physician assistant board meeting is October 24, 2016. Thank you.
Thank you, Dr. Bishop. Any questions to Dr. Bishop? Any public comment? Any comments on the phone?
Do we have any comments on the line?
And we have no comments on the phone lines.
Thank you. Mike, I know it's just a little too early, but how is the breeze for the PAs working out in a 1 or 2 months?
I'm sorry, we haven't heard any major complaints. Seems to be working out quite well, as a matter of fact.
Yeah. So we were the experimentees, Ms. Lally. We fixed all the stuff and they're all fine. So with that, we'll go to the last item today. Oh, thank God. Agenda item 14, election of officers. I would like to ask for the nominations for the Secretary of Medical Board of California. Can I have a nomination? Yes, Dr. Kraus.
This is actually more difficult than it would seem, because having served on this board for a few years, I am firmly convinced that everyone who is sitting here would be a fine executive officer. Nonetheless, I would like to nominate Ron Lewis for secretary.
Dr. Lewis, you're okay with it, I gather.
I accept, thank you.
Any other nominations? If not, Lisa, please.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Ms. Wright?
Yes.
Dr. Yip? Dr. Gonadev?
Aye. The next one is, I'd like to ask the nominations for the Vice President. Dr. Kraus.
I've actually spent quite a bit of time thinking about our leadership, and I wish that she could have been here today, but our board member Denise Pines I think would be incredible as our vice president, and I think that she's willing to accept the nomination, and I'd like to put her name forward for that.
Thank you. Any other nominations? I can vouch for Dr. Ms. Pines too. She's a wonderful person. Ms. Toof.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Ms. Wright?
Aye.
Dr. Yip? Dr. Gonadev?
Aye. The last one is, I would like to ask for nominations for the president. Dr. Kraus.
This nomination causes me great personal discomfort. And I must reveal a conflict of interest because I had a acquaintanceship and friendship and high regard for this individual prior to our service on the board. But I'd like to nominate Dr. Deb Gnanadev.
I don't even know if we can conduct this election, but any other nominations? If there is any, I would recluse myself and leave. I think I'm doing the right thing, so if not, Ms. Toof?
Dr. Bolott?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye, aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Ms. Wright?
Aye.
Dr. Yip?
Thank you. That concludes the meeting for today, and I do actually want to thank the board members for your confidence in the executive, in the officers for the medical board, and as I can mention to you now that any one of you who is interested in any committee, please feel free to call Ms. Kirschmeyer or I. We're going to revamp all the committees within a month. With that, we'll have the meeting adjourned till 9 a.m. tomorrow morning.